Hi, I'm so happy to have today Nick Murdoch with us because she's gonna tell us many interesting things which I never dream of, at least not myself. But I know many of you dream to have your invention used in the market and make money out of it. And thank you, Nick, for coming to the show, to the podcast. I know about you that you are an engineer and a lawyer in the same time. You started as an engineer. You have a bachelor in engineer. You after that you do your law school, and you combine those two. Not only law school, you have a PhD and you have many credentials, and you know very well this field of invention and protecting your invention. And I know you made a law firm in Australia. We're gonna put the link. I'm gonna put the link in the video of the description so people can reach out to you. You have there quite a good team taking care of the legal aspects of invention, trademarks, and more other interesting stuff.
Yes.
And what else you can say about you?
No, that's pretty much it.
Okay.
I help people protect ideas.
Okay, so let's help them protect the ideas. I have here a book which will summarize part of our conversation. Some ideas will be fine here. It's the book you wrote. I don't know when you had the time, but you made some time to write it. So get rich from the pitch we'll have a link in the description of the video so people can buy it and find out more things about the topic.
Yes.
So I have an idea. I think it's a smart idea, a useful idea, and I could make some money of it. What should I do with my idea?
Well, the first thing we advise people to start with is to work out whether the idea is actually an opportunity rather than a mere idea. So we try and get them to validate the idea to determine whether it's even viable in the industry and the marketplace at the moment. So there's a process that we put clients through that will help them work out whether the idea is a swimmer instead of a sinker. But the most valuable thing you can do with an idea is actually try and protect it legally, because obviously we're living in a very commercial, competitive marketplace. So the moment you launch, you're going to be looking at your competitors basically trying to do exactly the same thing. If you're making money off something, competitors will notice that and they'll try and emulate you. So the best thing you can do is actually protect the idea legally to try and have some rights to stop people stealing the idea once you hit the marketplace.
Okay, so how, let's assume that the idea is viable because you said first you test it, which I like it. I so like this idea not to go forward until you know that it's a good idea.
Yes.
So, okay, we go with the idea, which is a good idea further. How we can protect it, international, nationally, or what we do with it?
There's a series of laws we rely on to protect ideas. It's not just one law in itself. It's actually a bundle of laws. So we look at what we're trying to protect, what aspect of it we're trying to protect. So take for example, the functionality of something is likely to be protectable by patents. So patents protect devices such as simple mechanical devices, as well as methods of doing things, although it is difficult to obtain a method patent these days. Then in terms of the name of the invention or a byline, a logo, we would use a trademark. So a trademark functions as a badge of origin. So when you hear that word or see that thing, see that logo, you should think of the manufacturer. And if you've done that, or the source of origin of those goods, so if you've done that, the trademarks achieved its aim and achieved its function, is which is obviously to act as that badge of origin. And then we have other rights such as copyright rights. And copyright rights are a bit magical in a way, in that the moment you create something, it's protected by copyright rights. It's the expression of the idea, not the idea itself, that's protected. And it's your expression of the idea. So copyright rights don't protect against independent creation. So again, it's that expression of the idea. So you and I can both write a story about a cat on a mat, and it just so happens to be identical, the story. But so long as we didn't copy off each other, you can't claim infringement against the other. So then we have what are known as design rights, which are about the appearance of a thing. So you might have created a new style of cup, a new coffee plunger, or something like that, and you can register design rights. Now, in some countries, if you don't register the design rights, you can't rely on copyright rights, because obviously the design does have some schematics behind it, which would ordinarily be protected by copyright rights. So there can be overlaps, but design is an appearance right. Sometimes overseas, you hear them referred to as a design patent, but in my country, we refer to them as the designs. And then there's another type of right you can rely on that's actually quite difficult to rely on, but it's there as a last-ditch effort, which is rights that protect confidential information. So if you've got something that you use internally that's confidential that would give you an upper hand in trade, that's a trade secret, and it's confidential, and it's generally protected by confidentiality rights and the like. But they're the general rights that we can use to protect ideas. And when I say protect ideas, it's actually the expression of the idea and the solution that is protected, and it's the method of doing something that you get the protection for. And that's what you want, because at the end of the day, in the marketplace, people buy the solution. They don't just buy the idea. They buy what solves the problem they're facing. And that's how you make sales. And they're pretty much most of the rights that we deal with.
You have quite a palette of things to deal with. You have many. I was a little bit just a question for myself. For example, you said because this is the very wide creator expression. A story you said about a cat and a man. I like the cat example. So, because there are so many content creators and many copy paste a little bit from there, and I heard that books are made out of books, kind of. You copy from other and you
It's true.
put it
Yeah.
in your. So,
We're all just
how can you know that somebody doesn't copy yourself and doesn't give you credential? Okay, they copy something, but they give you authority that you wrote. They give you the respect mentioning your name. But if they
yeah,
don't,
acknowledgement. Yeah.
acknowledgement. Yeah, I was looking for the
Yeah.
word. Yeah, thank you.
There's a very fine line between simply copying something and footnoting that you've copied it. It doesn't necessarily mean you haven't infringed copyright. If you've done that, you can still infringe copyright
Oh,
by taking something and footnoting it. But there's certain conditions in which you can do it. It varies around the world. So all of the rights that we've discussed are what are known as jurisdictional. They're only enforceable in the country in which you've registered the copyright. Now, copyright rights don't need to be registered in a lot of countries. And copyright rights are also, depending on the country you're living in, copyright rights may be protected in other countries, even though you created them in one country. So copyright rights are a bit of a magical right in that respect. There's a convention that we're part of known as the Berne Convention, and we get national treatment in other countries. So that's why you see all of these court cases where somebody's infringed in one country and they'll be taken to court in that country and then possibly another country and so on and so forth. But that's one of the reasons why you see these large judgments as well, the large results, is because they might be starting an action in one country for the sake of infringement in every country that they can enforce in. But yeah, it's a very fine line between giving someone credit, taking something and not infringing. and it's a very difficult area of law, and a very dodgy area of law. There's a lot of exceptions, and one exception in one country might not be an exception in another country. And it's one of the things we're facing in the industry is that we're worldwide now. It's so easy to order goods from overseas, and it's easy to try and import something that you might not properly be able to import. But of course, you don't know that at the time. And copyright's a bit similar in that, if you publish a book, it'll be downloadable worldwide, or at least that's the option. That's the idea. It just doesn't. You might infringe in some countries, but not in others. So you've got to be really careful.
Let's say somebody copy your book, and you cannot sue them because they can do it. It's not.
Yeah. Detection's also a big issue. I mean, at the end of the day, how do you know, unless you've read every book on the planet, how do you know whether someone's actually taken your material? So there's some techniques we can use, some reverse searches on the internet and things like that we can try and find infringement from. But a lot of those kind of infringements will be tip-offs. So someone will write to you and say, hey, do you know that this is really similar to your work, or something like that. So tip-offs work as well.
I don't think you're gonna have this problem because your book is quite unique, and I was drawn to it. It was wow! To have this in a book to me is because you have to go to a lawyer and pay a consulting fee to
Yeah,
get the basic. And of
yeah,
course, after that, you go with the specific invention, with the specific creation. But anyway, you might have an idea from the book what to ask from the lawyer, and
mm.
yeah, to start the process.
Specific legal advice in the book, but the book is basically broken up into the elements of the pitch. So we talk about how to validate an idea, and then how to protect the idea. But what we find in industry is a lot of clients don't realize that there's lots of routes they can take once they have an idea. So we try and go through that. There's three main exits that people have, and they are things like people want to invent just to sell the idea away, and take the money and run. Then people want to license it to those who are more qualified to get it to the marketplace. And all they do is literally license it to another organization, and that organization takes the idea and runs with it and pays the person a royalty. And that's a wonderful scenario for people who have invented things that aren't in their own industry, because they don't have that ready-made sales channel. But it gives them an income from their idea, and it's a lot less risky for them because somebody else is doing all of the manufacturer and has to worry about returns and the like, and has to worry about getting it to marketplace. And then there's the normal route that people want to take, which is invent to commercialize. They want to invent to run their own company. So they want to do a startup. But again, when we're looking at startups, what we see is there's different personality types that you need in a startup to make it work. One person cannot be everything. No matter how talented you are, you won't make it a go if you're just by yourself. You need to team up with a team. So we've got some personality tests in the book that you can take to work out what personality type you are, to work out what other personality types you need in your team to make it, or your startup squad, to make it worthwhile, to see if it's going to work.
Yeah.
And then we go through the final frontier, which is actually how to pitch to inventors, investors. So we talk about the different investment stages and where to find funds, and what kind of funds you can raise at whatever type of maturity your company is at. And then, of course, what goes into a pitch. And we give a bit of information about how to give that pitch to try and get some.
And how to find investor in another meeting, because
Yep.
It's so important, and so many people doesn't know how to approach investors.
Yes.
It's
Yeah.
it can be fear there.
Yeah.
You
Yeah.
don't
And
know the not knowing.
there's a psychology to that as well,
Yes.
because you've got to put yourself out there. And a lot of people find that very, very uncomfortable. And inventors are a really interesting personality type. They're a very rare personality type. There's only about 2.5% people in the world who are the inventive personality type.
Hmm.
And what's fascinating about inventors is they don't realize how inventive they are. They don't realize this wonderful talent they've got, but they're either going to be extroverts or they're going to be introverts. And the problem is that if you're an extrovert, it's really easy for them to approach investors because they're used to putting themselves out there. But then you've got the personality type that just doesn't want to put themselves out there. And so it becomes very uncomfortable for them. And they've really just got to learn to put themselves out there, because it's not a case of build it and they will come. You have to go to them. They will not come to you.
Yes. Do I need to patent the invention in order to make money? Because okay, I
No, not at
invented
all.
something and
It would be lovely if you could, because patent is the best protection you can have. It really is. So what a patent is a monopoly granted by the government. It's a bit of a deal that you make with the government saying, I'll release my confidential information about how to make this work and teach people how to make it work if you give me an exclusivity for a period of time where I can stop other people making this so I can make some money off it. So it's
Mhm.
that's the bargain for a patent. And so you obviously being able to exclude other people from making it, that's what you want in the marketplace. Like that's an ideal position to be in the marketplace. You're the only source of the goods. People want to buy them, they have to buy from you. It's a great position to have. But it's not the only position to have. And there's other ways to make money from inventions that you don't, where you don't have to patent. And some ideas aren't patentable. We can't patent absolutely everything that we create. So sometimes you've got no choice but to protect it in other means. And they are things like that design, copyright, if you can survive the overlap between designs and copyright, trademarks. Sometimes just being the first to market is the way to go. So there's lots of different ways you can make ideas work that's not patent, not through the patenting system.
you patent in order to have your idea commercialized for a limited time on your benefit
Yes.
because you came first with the idea. And so these are limited time, not unlimited, or could be unlimited too.
So patents are limited in time. The longest you'll be granted a patent is 20 years, unless it's a pharmaceutical style patent, and then you can be granted up to 25 years. There is an older type of patent that would only last 8 years, but in Australia you can't be granted those anymore. So a patent has got an upper limit. It eventually dies. You do have to pay, in Australia, you have to pay yearly fees. They're known as annuity fees or maintenance fees. And around the world, it varies. In Australia, you have to pay them yearly. I think in America, it's every 3 to 4 years. Other countries, it's every 2 years, etc. But you have to pay to maintain it. For trademarks, so long as you use it and you don't get it removed from the register, you can renew that every 10 years forever. So you see some very old trademarks that have
Yeah.
been in the industry for quite a while. Copyright rights. Copyright rights are, again, a really strange type of right, in that copyright rights can be protected these days for the life of the author plus 70 years.
Oh,
So that's potentially not only the life of the author, but also the life of the children, and maybe
yes.
even the grandchildren. So copyright rights last a very long time. Design rights expire, and design rights, the length of design rights really change around the world. Up to 25 years in some countries. In my country, it's only 10 years, but you have to pay a fee at 5 years. So if you don't pay your fee at 5 years, it lapses. So, but yeah, and the biggest thing about all of these rights is just remember that most of them are jurisdictional. So you can infringe in other countries by selling into that country. So let's say I've got a trademark in Australia for something and I'm happily selling online, and I get a big order from the US and I think, woohoo, here we go. Finally, I've broken the international market. And so I export my goods into the United States. But unfortunately, there's a trademark over there, and I'm infringing that trademark by importing my goods into the United States. So I can get myself into a lot of trouble in other countries by exporting from my country. So when you're on the worldwide stage, it's really important to try and have trademarks and all your IP goodie protection as much as you can around the world to try and make sure you don't infringe other countries.
Okay, then I have a question. Like you said, in your country you are okay. So when somebody wants to export a good uh, uh, or a course could be or something creative which could be very similar with something else, you have to contact a lawyer there. How do you find that you there is something like that there and you don't step on someone else's feet?
It can be a very expensive process. So what we suggest is you conduct what's known as clearance to use and register searches. So before you file a trademark or before you use a trademark, you should conduct what are known as clearance to file to use and register searches through competent lawyers, and that they will conduct searches for you to work out whether you would be infringing in those other countries. Now, sometimes that means we actually have to contact our comrades overseas, so our colleagues. So if we were to conduct a clearance to use and register search in the United States, we'd actually use United States agents. The reason we do that is not because we can't search the register. We can search the register. It's a free access register. But the question is whether is this trademark too close for that trademark? That's something that needs to be answered by people who are experienced in local laws. So that's why we use those local agents, because they're best placed to answer the question. But yes, you have to be very careful when you receive overseas orders to ensure that you can actually fulfill the order without infringing the rights overseas.
I do follow some pharmaceutical companies who, for example, they issue a EpiPen, the alternative for EpiPen, which is very painful now with the shot, and they invented something which is sublingual or spray,
Oh,
which is
wow.
very easy to
Yeah,
use, much easier than a
yeah,
needle, but they cannot release it in US because there are EpiPen. It's still on the market, and I don't know, until 2027 or something, they cannot release to the market the
yeah,
new product, which will be more beneficial to the people
yeah.
to use a spray instead of a needle. But
Yeah, there must be a reason that they must have a patent over that or something like that. But one of the worst things about patents is it doesn't protect against independent creation. So you can have the idea, and 10 years later, I can come up with the idea completely independently of you. But because you got the patent, I can't use my idea. And that's unfortunately how it goes. That's how it works with patents.
and you gave a nice example in the book, and I like it. Now a little bit, maybe I switch on the side. Einstein, and I knew it, but I like it that you emphasize it in the book, like an example that other people invented, but he made it more friendly use, let's say more accessible
Yeah,
and more, friendly use.
yeah, yeah, yeah,
So if you take an idea, let's say it's patent and it's kind of hard way use, like I'm thinking EpiPen now, the needle, to
yeah.
me, the needles are hard to accept. And the spray will be something easier to use. Um,
Yes,
okay, it won't be the same formula for sure. I'm not a doctor, I'm not in the medicine, but I'm just thinking as a user, friendliness of using.
yes,
I'm thinking why the spray company, let's say, like Einstein, patent his invention. And did he wait so long? Like the guys with the spray, they have to wait for the 20-25 years to expire in order for them to enter in the market, let's say.
it
So,
depends on how infringement's a really interesting test, really interesting to try and work out. But it depends on whether they would be infringing. If they're not infringing, then obviously they can go ahead. so long as they're not breaching other laws. But there must be something about it that they're infringing, and maybe it's the chemical rather than the delivery method. I'm not sure. I don't know. I don't have the patent in front of me, so I can't really
Yeah.
answer your question. But yeah, this is the way the cookie crumbles. But you can do inventions are a bit like standing on the shoulders of giants. So because information has been released before, you now have the benefit of that information, so you can make something better. So, but the problem is you're going to get caught in the patenting process. So sometimes you do have to be patient as patient. Patience. Have some patience and wait for the patent to either lapse or expire, and that's just how it goes sometimes. But also realize that you're getting the benefit of that knowledge earlier as well. That you wouldn't have known the secret herbs and spices that they had in the EpiPen if the patent wasn't released. So you are benefiting from that in the long run. But the other way people get around that is they work out a better way. They work out a better way to do it that doesn't infringe the patent. So in that respect, it does push technology forward, because people are saying, well, I don't want to do the same thing as these other people because I would be infringing the patent. So instead, I've got to find a better way to do it. And that's exactly what they do. They try and work around the patents, and there's a whole series of case law and law about avoiding a patent and whether that would actually infringe the patent. And it's a really interesting area of law, but well, for nerds like me, but it's really interesting to watch people try and get around a patent, and sometimes they just have this amazing inventive spark just to get around the patent. And if the patent didn't exist, they wouldn't have created this new thing. So we benefit from the fact that they were hamstrung by a patent because they've invented something new. So sometimes, unfortunately, that is the way the cookie crumbles, in that you can't launch your new invention because somebody got to it first.
Yeah.
But again, that can often motivate you to create something better.
It's like a competition. Competition makes my view as well.
Competition with everything that went before. Mm.
Yes, yes, and to be better than the others, because
Yes,
yeah.
and
So
that's actually the secret to patenting, is you want to be better than the competition, and you want all of your buyers, all of the buyers, to come to you. So if you've got an invention that the competition isn't allowed to sell, the buyers have to come to you because that's the only place they can get this thing that they really, really want.
yeah, I'm thinking pharmaceutical because it's so you need the help. But I know there are so many inventions there. Even I'm thinking even internet we use it so nicely. But too bad I don't know if they patent the internet somebody to get some royalty from it. They will be rich people. But so can you be rich if you're an inventor, or you?
Oh yes, there's a lot of money in inventions. Think of how much Viagra would have made. Think of how much Wi-Fi made.
Mhm.
And oddly enough, there are some people who make more money off taking people to court for infringing the invention than they do the invention themselves. So there's a technique people actually use in industry, is that if they see somebody infringing their patent, they will wait until that person makes a lot of money. And then once they've made a lot of money, they'll pounce and bring infringement actions against them to try and get some of that money. And sometimes that results in them getting more money than what they're making themselves. So it's a technique, this waiting technique, waiting in the bushes to pounce, is a technique people use because sometimes they can't commercialize their own invention. Sometimes they just don't have the skill set to get the product to market, but others do. Others are doing better. So in those situations, oddly enough, it can work quite well, in that you bring the infringement claim, they have to pay you for the past infringement, but then you make a deal with them and you say, well, you're making more money than I am. How about you license it? So pay me royalties. Keep using it. Keep doing what you're doing. You're doing well. Good on you. But you got to pay me some royalties. Sometimes it works out quite well.
I wish I have an idea. I'm not an inventor. I'm not in that type of personality.
Oh, you probably have 1,000 inventions a day. You just don't realize it.
Yeah, you know better. You've met many people in invention. Yeah, we have to be creative, I think, all the time. I was thinking I'm more as a visionary when I read your book. Every
Yeah.
personality has its place on earth.
I think with these personality tests that we take you through, just remember that there's elements of all of those personality types in a person. It just depends on which ones are more dominant in that person. So, and we all have moments of personalities of they're showing personality types of ones that are just not us. We're just not having a good day that day, or we are having a good day that day. But yeah, it's all a matter of degree.
Yes, and that yes, of degree, how you are born with, and maybe how you culture the skills,
Yes.
the and education practice. I do have here a neighbor next to me, and she had a son, 10 years old. She was telling me he's inventing something, and
Ah.
I will pay for it $10 if only if I like it, only if I find it useful. Then I'll give him $10. I like
Tough
it.
mum, $10. Oh,
10 years old boy. $10. I hope $10 is
$10.
a lot of money for him. I hope so.
I
Otherwise,
know.
you
The
go
poor kid.
bankrupt fast if he's inventing every day and actually you
Oh,
develop the
you got to
skill.
motivate him. If that
Yeah.
motivates him, that's great.
Yeah,
Yeah.
no, and he was working because I was visiting her and was very concentrate on the invention too. I'm glad that there are people who invent things. And what I want to say about your book, because I found it and I like it, in the
Thank
back
you.
of the book, but okay, the back, you have where the institution where where you can go and find about patents and trademarks in every country. I think I didn't read, but you have quite a few pages. I didn't look if it's, for
Yeah.
example, Romania there, because I'm from Romania originally, but now
Mhm.
that I'm curious, I'm
Well, part of the problem is that people don't know the resources that are out there that can help them. So we've got a resource section at the back of the book, as well as a bit of a dictionary at the back of the book, so you can understand some of the terms that are used in patenting. Patenting actually comes from the 1600s. And funnily enough, some of the language we're using mirrors the language that was from the 1600s. So you really need a dictionary sometimes. So we gave you one.
in medicine, I think, is the same. They use Latin terminology as well.
Yes.
That was
Yeah.
long time ago. Means they
It's a
did a good job
very old
then,
process.
because it's
Yeah.
still understandable and still, yeah, people can communicate with that kind of
Yes.
language. They know what they are
Yes.
talking about. So
Yes.
nothing wrong with that. I'm gonna put the link of your practice as well, because I know
Thank you.
you have EAGLEGATE, you have quite a few team, you are a few lawyers
Yes.
there addressing the needs of your clients. I'm saying now to audience, please feel free to reach Nika and her team, and good luck with invention and making money of it. And we'll see you next time to talk about how to find and how to get more money funds from investor in order to launch the business after we have the idea how we launch it. Thank you very much, Nick, for your time, and see you next time.
Thank you for having me.
Bye.